Good afternoon. My name is Tom Mowbray, and on behalf of Google Australia, I'd like to thank the Commonwealth Government for this opportunity to share our ideas and have our voices heard on the matter before us. Google Australia is keen to see Australia's copyright laws fully embrace the 21st century and Web 2.0 services. As it stands, Australia's laws have made some inroads, but further steps are needed to properly allow Australian companies, like Google Australia, to reach their full potential. In the US, safe harbor provisions allow Internet Service Providers, or ISPs, and websites to avoid liability for copyright infringement in certain circumstances. This was a crucial step in the explosion of Web 2.0 services. Without these provisions, the Internet as we know it today would not exist. In 2006, Australia enacted similar provisions. However, it limited their operation to ISPs. This has created a double standard in the online world. While companies like Telstra Big Pond, Optus and iiNet can avoid liability if its users infringe copyright, popular Australian websites like Google Australia cannot. Rather, websites like us are subject to strict standards. If our website controls links or posts that might be used to infringe copyright, we must take steps to ensure such infringement does not occur. This means we can be held financially liable for a breach, even where we are not aware of it. This places substantial burdens on locally based websites. As we grow, we must commit ever-increasing resources to fulfill these duties and do not incur substantial liability. This stifles our and other websites' growth, negatively affecting our collective performance. Further, it discourages the local development of Web 2.0 services, as well as the extension of existing international services to Australia. Simultaneously, the laws encourage operators to relocate to a more forgiving jurisdiction. From a broader perspective, Martin Hosking, the CEO of Aussie startup Redbubble, recently observed that while these outdated laws remain in place, we'll never see the next website like Reddit or Pinterest launch from Australian shores because, quote, they would immediately get sued out of existence. These two companies are worth a combined total of $6.8 billion US. So long as Australia keeps these laws, the government is potentially waving off billions of dollars of local enterprise. For these reasons, the domestic juggernauts like the Federal Productivity Commission and the Australian Law Reform Commission have recommended that Australia adopt safe harbour provisions, and why Google Australia joins them. It's time Australia gave our local operators a fair go. The current laws are born out of the age-old penalise and deter way of thinking. The tired us versus them, all or nothing narrative should be left in the past where they belong, and we should move on to adopt a collaborative, reasoned approach that more effectively achieves the goal at hand, the reduction of copyright infringement. It's time to extend safe harbour provisions to websites. Now, there's no doubt a lot of noise surrounds these provisions. The Murdoch press will have you believe websites just want these protections because we're kleptomaniacs who want to loot and plunder the internet with no legal repercussions. They'll have you believe websites will gain blanket immunity and gain a license to steal from up-and-coming Australian artists. These claims are wholly untrue. They are inaccurate and their fears misplaced. The provisions would not allow for open season on copyright infringement. The Australian government can and should extend the safe harbour provisions only to actors who fulfil certain conditions. In the US, websites only enjoy immunity from liability if they themselves do not post the infringing material, nor manually edit or approve the material, nor have knowledge of such a post. These websites must also have in place a process by which they can receive notice of infringing materials, and once identified, they must remove or block the material expeditiously. Further, the websites must not receive direct financial benefit from the breach. Similar schemes are in place in other countries, including South Korea, Singapore, and across the EU. Indeed, even in the Australian context, the existing immunity granted to ISPs is contingent upon very similar conditions. There's no reason to suspect that websites' immunity wouldn't reflect these same conditions. However, it would be ignorant to pretend all Australia needs to do to solve its problems is to enact the US system verbatim. The US experience with safe harbour raises some serious concerns. Because websites' immunity is only ensured if they remove reportedly infringing content, the trend is to remove anything that's flagged. In the US, users have manipulated this system by reporting anything they don't personally like as infringing copyright. For example, parties have been known to falsely report criticism of their work in efforts to remove it, and in some cases it's been successful. This issue is compounded by the fact that even where posters dispute the infringement, their post cannot be restored for at least 10 days, and if the issue goes to court, the website loses its immunity if it reinstates the post before the decision is released. These are legitimate concerns, but they're not insurmountable. The US experience provides us with valuable lessons. We can alter or remove these problematic compounding factors from our own legislation. We can legislate additional conditions ensuring that websites give reportedly infringing parties a chance to respond and have their post reinstated. We can adopt the dicta enunciated in the US case, Lenz and Universal Music Corporation, which stated that fraudulently reporting parties may be liable for damages or, as Amy Blom has suggested, perjury charges. In the interests of transparency, the government might also establish a public database for reported infringements, so reported infringements are subject to scrutiny. Finally, we at Google Australia would like to leave with our most important point. Safe harbors work. Last year, a US counterpart received almost 1 billion reports of copyright infringement. That's 100,000 reports every hour. Under the traditional framework, like Australia's existing system, such volume would be impossible. The Safe Harbour system grants people and organisations the ability to protect their work at an infinitely larger scale at an infinitely faster rate. Imagine if each of these reports were instead cease and desist notices. Imagine the time and the money it would cost in executing the necessary procedures, in communicating with the parties involved, in preparing legal arguments. And all the while, the infringement is still in place, potentially costing the suffering party more and more by the day. Safe Harbour provisions bring Australia's laws up to date with the realities of the web. The traditional framework was created in a time when our day-to-day reality was inconceivable. Imposing it on Web 2.0 services is like putting a square peg in a round hole. It's time we accepted that reality and brought our laws into the 21st century. Thank you.